the second day of today's symposium on creating a better workplace for women. And we have with us Ms. Tuhina Sharma Biswas. She is a practicing lawyer and she is a legal member in the ICC, Assam University. So to moderate the session, we have Dr. Sudeep Choudhury from Department of Chemistry, Assam University, Silchar. So I request Sudeep to please carry on with the session. Thank you.
Thank you so much. And welcome all again in this third session. And in this session, we welcome Ms. Tuhina Sharma Biswas. As already mentioned, that she is a practicing lawyer at the District Bar Association, Silchar, since 2003. Madam Tuhina Sharma Biswas actually did her MA from Nehu, and then she moved to Guwahati University for B.Ed, and there she continued and completed her LLB. And apart from that, being a practicing lawyer, she is an active women rights activist since last 10 plus years, and quite an experienced in that sector. Along with that, she is all Assam president of the Human Rights Association of India. Along with many other activities, especially the social and legal activities, she is a very good orator too, and we'll get a glimpse of her wisdom and oratory in her topic entitled Harassment of Women at Workplace, the Law and its Applicability. So till now, from different participants, different presenters, we have heard about mostly the other sectors of the women at workplace and the consequences, the challenges. And now we'll get a hardcore law and their applicability aspects from Ms. Sharma Biswas' lecture. And we are eagerly waiting for that. We welcome you, madam, in this session.
Thank you. Thank you. Thank you so much.
Welcome on screen.
Yes, yes. Good afternoon, everyone. I'm Tuhina Sharma, lawyer, District Bar Association. It's really an honor and privilege for me to be present here amidst all the dignitaries. This is a very new experience, and it is quite thrilling to see the side of the internet unfold in front of our eyes, allowing us to have this virtual meeting even during a global pandemic. While I try to stumble and find my way, kindly look over my lack of technical skills. Thank you. Today's topic is a very burning issue now in India, that is sexual harassment of women at workplace and educational institutions. So I will go in details about this and its legal implications. The typical man-oriented workplace has been replaced by a large number of women getting employment in every possible field of work. These have given rise to a number of issues that affect the integrity of the women and also have an impact on the physical, mental, and social well-being of the women. In its different forms, sexual harassment is still a part of the workplace, irrespective of the fact that it is committed to them. Women generally do not speak of the act of sexual harassment, but this is not a trivial issue to be lightly dealt with. Any act of sexual harassment can leave a woman with physical, mental, and emotional problems that would have a deep impact on her future life. The issue of sexual harassment has to be given a serious thought, and people's participation should be encouraged to make every workplace safer and healthier. Gender equality in protection from sexual harassment and right to work with dignity, which is universally recognized basic human right. The issue is not confined to the empowerment of the women, but this issue is related to the basic human rights of the women to work in a safe and secure work environment, being treated equally with the man and no fear of being a subject of sexual harassment at the hands of the male counterpart in the workplace. Sexual violence at college and campuses is extremely widespread in India. So it is very related, relevant because of what lecture I am delivering today. It is in the for and on behalf of Assam University. So I want to highlight on these points. There is a significant imbalance of power in colleges, and the teachers and administrative staff can adversely affect the students' future by lowering their grades and taking away extracurricular opportunities from them. This makes students particularly vulnerable to sexual harassment. Sexual violence that is perpetrated by students against other students is also prevalent. To check sexual harassment at campuses, the University Grant Commission put in place University Grant Commission Prevention, Prohibition, Redressal of Sexual Harassment of Women Employees and Students in Higher Educational Institutions Regulation in the year 2015. The Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act 2000 came to light in the year 2013. It is a legislative act in India that seeks to protect women from sexual harassment at their place of work. The act also provides the circumstances under which an act may amount to sexual. These are in brief I'm describing. Number 1, implied or explicit promise of preferential treatment in her employment, or implied or explicit threat of detrimental treatment in her employment, or implied or explicit threat about her person, about her present or future employment status, or interference with her work, or creating an intimidating or offensive or hostile work environment for her. Humiliating treatment like to affect her health or safety. The Act defines sexual harassment at the workplace and creates a mechanism for redressal of complaints. It also provides safeguards against false or malicious charges. The Act also covers concept of, it's a very nice Latin term, I must tell you, quid pro quo harassment. Quid pro quo harassment. In details, I'll be going on later on. And hostile work environment as forms of sexual harassment if it occurs in connection with an act or behavior of sexual harassment. The definition of aggrieved woman who will get protection under the Act is extremely wide to cover all women, irrespective of her age or employment status, whether in the organized or unorganized sectors, public or private, covers clients, customers, and domestic workers as well. An employer has been defined as any person who is responsible for management, supervision, and control of the workplace, and includes persons who formulate and administer policies of such an organization under Section 2G. While the workplace in the Vishaka guideline is confined to the traditional office setup where there is a clear employer-employee relationship, the Act goes much further to include organizations, department, office, branch, unit, etc. Homes, educational institutions, sports institutions, stadiums, sports complex, and any place visited by the employee during the course of employment, including the transportation. Even non-traditional workplaces which involve telecommuting will get covered under this law. The committee is required to complete the inquiry. This is a very important part of this within a time period of 90 days On completion of the inquiry, the report will be sent to the employer or the district officer. As the case may be, they are mandated to take action on the report within 60 days. That means total 90 plus 60, within 140 days, the entire inquiry will have to be covered up. Every employer is required to constitute an internal complaint committee at each office or branch with 10 or more employees. The district office is required to constitute a local complaint committee at each district and if required at the block level. The complaint committee have the power of civil courts for gathering evidence. This is a very important point which should be noted down. The complaint committee are required to provide for conciliation before initiating an inquiry if requested by the complainant. The inquiry process under the Act should be confidential and the Act lays down a penalty of ₹5,000 on the person who has breached confidentiality. The Act requires employers to conduct education and sanitization programs and develop policies against sexual harassment, among other obligations. The objective of awareness building can be achieved through banners and posters displayed in the premises. E-learning courses, which is very important now, because now we are in the virtual world. E-learning courses for the employees, managers, internal complaint committee members, classroom training sessions, communication of organizational sexual harassment policy through emails, e-learning or classroom training. It is recommended that the e-learning or classroom training be delivered in the primary communication language of the employee. Penalties have been prescribed for employees. Non-compliance with the provisions of the Act shall be punishable with a fine up to ₹50,000. Repeated violations may lead to higher penalties and cancellation of license or dedication or to conduct business. Government can order an officer to inspect workplace and records related to sexual harassment in any organization. Under the Act, which also covers students in schools and colleges, as well as patients in hospitals, employers and local authorities will have to set up grievance committee to investigate all complaints. Employers who fail to comply will be punished with a fine of up to 50,000. Guidelines laid down in Vishakha's case, which is a remarkable landmark in this respect. All employers or persons in charge of work, whether in public or private sector, should take appropriate steps to prevent sexual harassment. Without prejudice to the generality of this application, they should take the following steps. Express prohibition of sexual harassment as defined above the word place should be notified, published, and circulated in appropriate ways. The rules, regulations of government and public sector bodies relating to conduct and discipline should include rules, regulations prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. Appropriate work conditions should be provided in respect of work, leisure, health and hygiene to further ensure that there is no hostile environment towards women at workplaces and no employee women should have reasonable grounds to believe that she is disadvantaged in connection with her employment. Now I'll come to the criminal proceedings. Where such conduct amounts to a specific offense under the Indian Penal Code or under any other law, the employer shall initiate appropriate action in accordance with law by making a complaint with the appropriate authority. In particular, it should ensure that victims or witnesses are not victimized or discriminated against while dealing with complaints of sexual harassment. This is a very important part. mostly in our countries reported are less because of this. The victims of sexual harassment should have the option to seek transfer of the perpetrator or their own transfer. Disciplinary action, where such conduct amounts to misconduct in employment as defined by the relevant service rules, appropriate disciplinary action should be initiated by the employer in accordance with those rules. Complaint mechanism, whether or not such conduct constitutes an offence under law or a breach of service rules, an appropriate complaint mechanism should be created in the employer's organization for redress of the complaint made by the victim. Such complaint mechanism should ensure time-bound treatment of complaints. Now I come to the complaint constitution of complaint committee. The complaint mechanism referred to in the point number 6 above should be adequate to provide, where necessary, complaints committee a special counselor or other support service, including the maintenance of confidentiality. The complaint committee should be headed by a woman, and not less than half of its members should be a woman. Further, to prevent the possibility of any undue pressure or influence from senior levels, such complaint committee should involve a third party, either NGO or other body who is familiar with the issues of sexual harassment. The committee must take an annual report of the government department concerned of the complaints and action taken by them. The employers and persons in charge will also on the compliance with the aforesaid guidelines, including on the reports of the complaints committee to the government. Workers' initiative. Now I'll come to the point of workers' initiative. Employees should be allowed to raise issues sexual harassment at workers' meeting in any other appropriate forum, and it should be affirmatively discussed in the employer-employees meeting. Awareness. Awareness of the rights of female employees in this regard should be created, in particular by prominently notifying the guidelines, the appropriate legislation enacted on the subject in a suitable manner. Third-party harassment, where sexual harassment occurs as a result of an act or omission by a third party or outsider, the employer and person in charge will take all steps necessary and reasonable to assist the affected person in terms of support and preventive action. What should, the very common question which I face everywhere wherever I attend meetings, seminars, and all nowadays webinars. The question is, what should a female employee do who had been sexually harassed? Which I give more emphasis on this. This is show stern resentment. Number 1, when a woman finds the act of any man in her workplace to be offensive, she must be clear and strong in her resentment. She should clearly let the other person know that his act is offensive and would not be tolerated. This firmness should come from within. We'll have to give more emphasis on this point, that the women who are working, they should learn to say no. Number 2, speak out. The woman should discuss the issue preferably with her colleagues or some other person so that the act does not go unnoticed. Number 3, keep records. Report of the complainant. Number 4, the woman should make a formal complaint to the senior officers regarding the incident. Number 5, say no to situations one fears of bringing the risk. Should clearly say no when you are asked to go places do things and respond to questions or engage in situations that makes her uncomfortable. This is a very important and vital point. Number 6, get oneself medically checked in case of rape or the women should go for a medical checkup immediately and get a medical report. Number 7, file a police complaint. The woman who has undergone the trauma of being sexually harassed must file a police complaint so that the acts of the culprit should not go unpunished. Number 8, file a complaint with the Women Commission. Complaint can be filed in a Women Commission. A woman can also file a complaint with the complainant, with the Complaints and Investigation Cell of the Women Commission that would ensure that the investigations by the police are expedited and monitored. In case of the act is serious, the commission constitutes an inquiry committee which makes spot inquiries. This is also very important. Examines various witnesses, collects evidence and submits the report with recommendations. Such investigations help in providing immediate relief and justice to the victim of violence and atrocities. How is sexual harassment defined under the UGC regulations? It's very important because as we are today webinar conducted by Assam University. Section 2K of the regulations defines sexual harassment as an unwanted conduct with sexual undertones if it is occurs or which is persistent and which means humiliates or creates a hostile and intimidating environment or is calculated to induce submission by actual or threatened adverse consequences and includes any one or more all of the following unwelcome acts or behaviors, whether directly or by implication, including physical contact and advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography without being asked to, any other unwelcome of sexual nature, whether by way of physical or spoken or unspoken conduct. The following circumstances, among other circumstances, in relation to any act or behavior of sexual harassment may amount to sexual harassment, implied or explicit. So I'm coming in details. Implied or explicitly promise or preferential treatment as quid pro quo, the term which I uttered, the Latin term for sexual favors. Implied or explicit threat of detrimental treatment in the conduct of work. Implied or explicit threat about the present or future status of the person concerned, creating an intimidating, offensive, or hostile learning environment. Humiliating treatment likely to affect the health, safety, dignity, or physical integrity of the person concerned. The definition is similar to one found under Act dealing with sexual harassment at workplace. Now, very important another part which all of us we should know and we should be aware of that. What are responsibilities of a higher educational institution regarding sexual harassment at their own campus? All institutions must inform their students and staff about the sexual harassment guidelines, prominently display the guidelines in the college, and also hold workshops and seminars both for students and staff, and publicly declare a zero tolerance stance towards sexual harassment. More emphasis constitute an internal complaint committee for hearing
Yes, madam, we can hear you.
You can hear me? All colleges must also constitute an internal complaint committee, that is ICC, for hearing cases of sexual harassment, and in case there is already a complaint mechanism in the form of another committee, it must be reconstituted as an ICC. Half the members of the ICC must be women, and the presiding officer must be a woman employed at a senior level. People in high positions such as vice chancellors and heads of department can't be members of the ICC so far as to maintain its authority. Can you see the screen sharing?
Yes, it can be seen, but
Okay.
it is in smaller size. It needs to be in full screen mode.
Can I take 1 minute? Can I take 1 minute?
Yeah, okay, no problem.
Okay, I can start it. What regarding the complaint procedure must be kept in mind. The ICC must ensure that the identity of the aggrieved and the respondent are concealed and not made public during the investigation process under any circumstances. Another very important issue I am coming. What measures can ICC take to provide interim relief? After reviewing the complaint, the ICC can transfer either the aggrieved or the respondent to a different department in the college to minimize the contact. Restrain the respondents from the evaluating the complainant's work in any way, like evaluating exam papers. Ensure that the respondents maintains distance from the aggrieved, and if the offender presents a definite threat, then restrain them from entering the campus. Take all steps to ensure the victim does not face retaliation for making the complaint. Now I come to the point of punishment. If the offender is an employee, then he must be punished according to the service rules of the college. If the offender is a student, then they are punished based on the severity of their crime as evaluated by the ICC. They can be punished in the following way. Their privileges such as library access, scholarship ID card can be revoked. They can be suspended for a specific period of time. They can be expelled permanently, and they can be instructed to take counseling or to undertake community service. What is the basis of this? Aggrieved party is entitled to receive compensation from the offender. While determining the compensation to be received by the aggrieved party from the offender, the following factors must be taken note of: mental trauma, pain and distress caused to the victim, loss of career opportunities due to the crime, medical expenses incurred for physical and psychiatric treatment, status and income of the offender and victim, and feasibility of such payment in lump sum or installments. Now another question comes, but if a false complaint is made, yes, there is also a provision for that. In case of false or malicious complaints, whether complainant knowingly filed a false complaint, the complainant is liable to be punished. For educational institutions that do not comply with said provision, severe punitive actions are provided after providing due notice. Now I come to that term, very interesting term. What is quid pro quo? Kind of sexual harassment at workplace. Quid pro quo is a Latin term which literally means this for that. Quid pro quo sexual harassment means subjecting a woman to unwelcome sexual advances, requests for sexual favors, and other verbal, physical conduct of a sexual nature on account of the following. Just see the point, very interesting. To force the woman to agree with such conduct by promising or threatening her explicitly or implicitly. preferential or detrimental treatment of a job. For example, I'm just giving, if you agree to accompany me on a study tour, I will give you promotion, or in case you refuse, I will transfer you the place. Submission or to rejection of such conduct by the woman is used on the basis for deciding the future courses of her job. For example, to make it clear, I'm quoting example. If you refuse to obey my demand, I will not renew your contract. Hostile work environment, kind of sexual harassment at workplace, creation of a hostile, intimidating, or an offensive work environment with the purpose of unreasonably interfering with women's work performance or subjecting women to humiliating treatment likely to affect her health and safety. What is unwelcome sexual conduct? Again, I'm coming to this because this is the vital point of this act. A sexual behavior only becomes sexual harassment at workplace only if it is unwelcome to the women who is in receipt of such behavior. Who can complain about sexual harassment at workplace? Here, students means women above. Employee can, of course, they can complain, but I'm coming to the point of students, because students also, they should know. Students means women above 18 years of age. Those who are under 18 years of age can lodge an FIR under the Protection of Children from Sexual Offences 2012, which is called POCSO. POCSO has nowadays, we are finding, being a lawyer, every day I am finding in Kachar district, lots of POCSO cases are being filed. Does the act constituting sexual harassment have to occur at work? No. The act does not necessarily have to occur at workplace only. It could occur in any of the following places: social event organized by employer, during work-related, at a client or customer's premises, at training events, business or lunch dinners, promotional campaigns or public relations events with clients, customers or prospective partners, or during the course of work-related phone conversations or communications via electronic media. This is a very important point. Now, I'm just before winding up, I'm just coming to the end of this thing. If I'm a victim of sexual harassment, what should I do? It's a very common question being asked. If you feel comfortable in approaching the harassment yourself, you could directly tell the perpetrator that you find his behavior unwelcome or inappropriate and ask him not to repeat. If you are not comfortable, if you can approach the internal complaint committee established within your organization under Sexual Harassment at Workplace Prevention, Prohibition and Redressal Act with a written complaint. If your organization does not have any ICC, or if you want to make a complaint against the employer himself, or if you work in a capacity of domestic help, then you can lodge your complaint with the local authorities, local complaint committees established in your respective district, or you can contact the nearest police station to lodge an FIR against the perpetrator. This is the law and its applicability, its implications. But before I wind up, I must say, law will remain impracticable if we are not aware of the application of it, and if we cannot come forward with an awareness. So now I can proceed to the next session. If anyone wants to ask me anything about this, I'll be very happy. Thank you.
Thank you so much, madam. And it was an informative session, especially from the law and order point of view, because many of us, we know the theme, we know the consequences, but we do not know what actually the law speaks about it. So quite naturally, there are a few queries, rather there are many queries, but some of the queries you have already addressed unknowingly, though, in your presentation itself. One important thing is,
tell me.
please. One important thing is that there are many sexual harassment cases going on in the country. Let us consider our country itself. From a lawyer point of view, what do you feel? How to create a very conductive atmosphere so that these acts get reported, especially considering the present societal scenario in view?
Yeah. So I must tell you one thing, the data which we are receiving data of only those who have come forward, ignoring the red eyes of the society. But this is not the actual data. Already there are lots of women behind the curtain. Those who are afraid of facing the social mockery, they are afraid of facing the social criticism, they're afraid of facing the shame, bullying, and nowadays social trolling. So to solve this problem, awareness program should not be confined within us, within the victim women only, within the victim. Awareness program should be widespread among those who are the root cause of the problem, who are having very low thinking, low perception, low ideology. So awareness programs should be spread among those. Unless and until we cannot change a person from within, we cannot stop this crime. So awareness program will have to be spread in a different way. But what we do, we are doing the awareness program only among the victims. So this will not solve the problem.
At the same time, do you feel?
Yes.
Yeah. At the same time, do you feel that our present law and order system also should get modified? Because in many of the cases, it is an undeniable truth that we are speaking about Nirvaya case and any other cases, but these are very few cases where the law and order come up with triumph. But most of the cases, this gets undetected. Or the people get just they cuts the net of the law and gets away. At the same time, there are many false allegations are also there. So what your view that how the law and order should adapt itself to these type of situations?
Yes, very good question. Very good question. We lawyers are also we are also thinking on this point, and considering this point, few amendments have already come. Lots of amendments are Parliament has already brought lots of amendments in this respect to expedite the judicial process, because it takes a lot of time. We have seen in Nirvaya cases and other cases also. Some more already few amendments have been done, and we need more amendments to expedite the process. So yes, I also agree. We lawyers are also agree. We need more amendments in this respect. More amendments will be required. More amendments will be required, and especially women should be, especially those women, those are behind the curtain. I'm still again the curtaining the word behind the curtain. We should spread our awareness program among those women, among those sections of the society that the root cause of the problem. We'll have to think their low perception. We'll have to how to rectify their ideology. We'll have to think about that also. Unless and until this low perception ideology we cannot change, how law will be successful, it will remain impracticable. And it is very sad side being a lawyer, I'm saying.
It is true. And probably this is also true. And somehow the whole societal scenario probably has to get modified. And only in that type, the law and order also will get in tune with that.
And we'll have to add one more thing. We'll have to change ourselves from within. We'll have to change. We'll have to rectify ourselves from within. If we cannot, and always social stigma, nowadays so social media is very active in each and every case, like you'll be finding trolling and all. So facing all this, facing the red eyes of the society, so we are not going to get the exact data. We are not going to get the exact data. This is I'll say maybe it is a 20% of the total cases.
True. True. And at the end, probably, we'll have to tell another thing, that the law and order should be impartial also. To some extent, especially in such cases, this is not very much impartial, if I say. For example, in the case of domestic violence, as we say that the law speaks differently under different situations. And
Yeah.
the law means we have to do a lot. We have to go a lot ahead to get a very nice society, and we believe that in coming years we'll see the fruit of it.
We will get, and I must thank Assam University for taking this initial. We need to have more social, this kind of, though virtual, we need to have more awareness program, more
Absolutely.
and more awareness program. So thank you so much, and I'm really once again I'm privileged, and I would like to participate this kind of awareness programs.
Thank you so much, madam, for being with us. It has been very informative for all the participants here, and thank you so much again. Thanks a lot.
Thank you.